and welcome to the Arbitration Conversation. So in this webisode, we're going to be talking about Canadian arbitration law. And with us today, we have Jonathan Eades. Jonathan Eades, a clerk for Justice LaForest at the Supreme Court of Canada. He also was called to the BC Bar in 1996 with Davis & Company, which was his first law firm. He practiced in civil litigation in Toronto and then spent several years with the Paris arbitration group of a US law firm, Jones Day, working exclusively with investment treaty cases. Currently, and he was named the Senior Legal Counsel with the British Columbia Ministry of Attorney General in 2012, which is where he remains with British Columbia. Thank you so much. Thank you, Jonathan, for taking time with us. You're a true expert. I could go on and read the rest of your background, but we'll have to post it on the website because it's so long. So thank you so much for being here with me.
Thank you, Amy. It's a delight to be here. And I love this idea. I love the idea of the arbitration conversation and sharing ideas across the world, because certainly my experience, I've been influenced by what I experienced overseas, and we help cross-pollinate each other with ideas. And so this is a great project you've got going, and I'm pleased to be part of it.
Well, it's a perfect segue into the topic because the Canadian Arbitration Act, really interesting in terms of kind of the evolution, where it's been, where it's going. So maybe you could start by just giving a little bit of background about the Canadian arbitration law.
Sure. I don't want to bore people with Canadian federalism, but really the provinces in Canada, and I'm in the province of British Columbia, do most of the heavy lifting. My federal colleagues would be upset to hear that. Very different than in the United States. We have a federal arbitration act, a Canadian International Arbitration Act, a Canadian domestic, but most cases aren't decided under those acts. They're decided under the provincial legislation. So, for example, the acts that I'm very familiar with are British Columbia's International Commercial Arbitration Act, which is a model law act. In fact, one of the first model law acts in the world, and our Domestic Arbitration Act, which is not a model law act, as of today, being August 7th, 2020. Come back on September 1st, it's all changing. We're going to have new model law domestic legislation as well. So this is a project I've been working on for a couple of years with some wonderful colleagues in Canada, including Henry Alvarez, which your viewers will know, Jerry Kikas, others have been involved. It's a great project. We're going to have a really wonderful new user-friendly arbitration act coming in. So I want to give that background. So when, for example, an American is thinking, I'm going to arbitrate in Canada on one of the pieces of legislation, you're probably going to be arbitrating under a domestic act. So the provincial legislation will be really important for you to understand.
Yeah, and this is what I really kind of want to dig into. In fact, I was thinking, and as I shared to you earlier, so when I used to practice law in Seattle, actually a lot of our clients were Canadian, and we had an office in Canada as well. And so we would have been actually arbitrating in British Columbia, most likely. So these are really important issues for Canadian, American, actually a lot of lawyers and practitioners throughout the world.
Absolutely. Now, of course, you can always have your hearing in a place like Vancouver, which is a beautiful, wonderful place to have a hearing, and you can arbitrate under any piece of legislation you want in the world. But if you're coming here and you're contracting with a British Columbia entity, and depending what your contract says, you might have our British Columbia. Well, if you're an American, you have our International Commercial Arbitration Act would apply in that circumstance. That's model law. They will be very, very familiar with that. But perhaps the U.S. sub has a British Columbia entity or Canadian entity, which has a contract with domestic issues. You'll be under our Domestic Act. And as I say, in 3 weeks' time, you're going to have this great deal of harmony between the two acts, which is going to really up the bar in terms of our practice here in British Columbia. And although it's great already, we're moving away from, and if there's colleagues out there from Australia, New Zealand, England, they will understand what I'm talking about. Those jurisdictions had an old Commonwealth model law. It was an early model law. It was wonderful in its own way, but it has not stood the test of time, and including in England, it's been essentially gone since 1996. Australia moved very forcefully and admirably in 2010, both at the federal level and at the state level, to a more model law approach. We were really inspired by what they did. We're doing the same thing.
Well, and what are some of the main differences, I guess? So yeah, I'd be really curious to hear your take on what are the main differences from the old to this new coming in September.
Structure, ability to actually follow the act. The Commonwealth Act, frankly, is impenetrable in many ways. Very, very dense. It allows for more court intervention than the model law does. We think it's very important as a trading province to be able to speak in a language that everyone understands. And that includes both internationally, which we got way back in '86, but also domestically too. That's one of the main differences. Mind you, there are some differences, again, which our English and our Australian colleagues will understand. We still do have, which is not model law, we do have a limited ability to appeal questions of law which arise from the arbitral award. Mm-hmm. However, and we can talk about that mechanism. That's an English law introduction in their 1979 legislation, Margaret Thatcher. Interesting idea. We went with it in the mid '80s as well, but it's become too cumbersome, too costly, too time consuming. It still exists, but it's much, much more constrained now in our new legislation.
And that's a distinction which is very different from the Federal Arbitration Act in the United States, because they don't allow for that same sort of review of questions of law.
That is correct. There is an opt-out, though. You can opt out of that process altogether, and that's a new feature, sort of moving in the direction of the Federal Arbitration Act, although I'm not an expert in that act at all. But I know that the Americans follow that approach. For your viewers, you have to be careful in Canada because, for example, Quebec also doesn't have a right of appeal. Different provinces treat it a little bit differently. It's largely, basically assume in Canada, there could be an appeal if you wanted, but you can opt out. That's a good working assumption for foreign counsel.
And so back to kind of talking about this new act coming out in September. Again, this is just British Columbia, correct?
That is correct.
And also, so as far as like harmonization, will it be harmonizing more or less with the New York Convention to a great extent?
Yes, we're a New York Convention compliant jurisdiction internationally, completely. Yeah, that dovetails perfectly there. We also harmonize now, British Columbia, much closer harmony with our provincial partners in Alberta, Saskatchewan, Ontario, Manitoba. All of them also have domestic acts which are largely model law influenced. They're based on the Uniform Law Conference of Canada, a model which was developed in the early 90s. We're the next generation. We've also been influenced by what we call ULCC principles developed in 2016. We had, in fact, on our team drafting here, some of the leading people from that project came over and like Jerry Geekus and worked on this project. So we've had a top-notch team to make sure absolutely like matters like the New York Convention compliance, the awards are enforceable around the world. Absolutely.
So, and yeah, it's going to be, starting up in September. Do you think that this will be something that will, I guess so, if international law is still going to govern if you do have international parties, but to some extent, do you see Vancouver then becoming more of a seat for more arbitrations, perhaps?
We'd certainly like to see that. We see Vancouver has some natural attributes. It's clean, it's safe, it's neutral, it's close to the US, obviously, but as we spoke about the other day, we remain distant neighbors at the same time. It's an independent country. It's a bridging place between New York and Asia. Hong Kong right now, obviously there's issues. People will be thinking, where do I want to have my arbitration? Usually that's decided by which party is most powerful. But Vancouver is, I would say, the best second choice you can have possible. You want a compromise option, and often it is the seat and even the hearing location can be a compromise. we think that Vancouver is a wonderful compromise. Of course, you don't need our legislation to come here, but it's here. Just things like airport accessibility. If you've ever flown into Vancouver, it's a great airport. It's right next to downtown. All of that stuff makes a difference. Hotels, et cetera, et cetera, et cetera. I should mention this actually as well, that we have had a historic relationship with the British Columbia International Commercial Arbitration Center. In fact, they actually have some statutory duties to make appointments instead of the court arbitral appointments under the Domestic Act. They're rebranding as part of this exercise. They are now going to be the Vancouver International Arbitration Center, or VANIAC. That's also happening on September 1st. And we work very, very closely with them. That's kind of a unique thing too, because a lot of jurisdictions in North America won't have a working relationship necessarily with an arbitral institution. We welcome and work with all our arbitral institutions, domestic or international, but we have had this historic relationship with the BC ICAC, now VANIAC, and that continues under the new legislation.
So I'm curious, with the new law, I wondered, is there any mention of technology, or do they bring in any aspects? Because it being a current law, in the United States, the Federal Arbitration Act was passed in 1925. So obviously they weren't thinking about virtual hearings. But I'm curious as to whether there is any mention of technology.
There is. I mean, I don't think it technically needs to be in the Act, but there's a provision that allows for just a wide open range of options for procedures. And it does mention, it gives a list, but it's not prescriptive. It just is a sample to allow, essentially tell the courts, listen, if you do any of these things, it's all fine. You can do what you want in an arbitral proceeding. Sure, virtual hearings, you have the hearing outside the province, you don't have to have a hearing at all, the strict rules of evidence don't apply. All of those things are built into the Act. There's actually a built-in presumption that the hearing will be the direct evidence will be received in written submission. Now that can be moved off by the parties or the arbitrator, but we sort of put the finger on the scales a little bit there to push parties and arbitrators in the direction of, listen, let's shorten this up. The way we all know that arbitration can and should work, the arbitration hearing should be cross-examination. That's what it's all about. It's not about direct evidence or limited direct only. So we've pushed that in a direction to achieve a certain result, to encourage people, if they want to arbitrate, arbitrate. Don't litigate. If you want to litigate, that's great. The state courts are there for that. You don't have to arbitrate, but if you're going to arbitrate, arbitrate.
So if you were to kind of give any sort of pitfalls or things people should really be aware of that are going to be major changes, is there anything in particular you would want to alert somebody? Because I definitely understand as far as the harmonization and structure and some of these issues, the question of the questions of law and appeal, but is there anything in particular that really is a kind of a major change that people will kind of step back and say, wow, it's September 1st, I better read the bill, Is there anything?
I think you've named it already. I think the appeal provision is really the biggest change. Maybe one of the biggest changes is something that didn't change at all, which was the stay proceeding provision, and that's an interesting story too. What British Columbia did in 1986, it simultaneously kind of did two different things. It went ahead with internationally the model law, but domestically decided to just kind of tinker with the old Commonwealth Act. But it said, well, we're going to make changes to the stay provision. We're going to give the court all sorts of discretion to make stays. They didn't go with the model law stay provision, which is very strict, as you know. The end result of that was a tremendous amount of litigation for 2 years. And the British Columbia government of the day said enough and killed this novel stay provision and went with a model law stay provision. So in other words, one of these critical pieces of our act was in fact already model law way back in '86. I say that what's important there? Well, we're continuing with that. So we've already built up very, very good stay jurisprudence in British Columbia. The British Columbia courts get how stays work in a model law context. The courts are very reluctant to override the party's intent to arbitrate, which is great. Where we have had historic problems, though, is on our appeal provision. that has caused problems. And that is, though the courts have really made wonderful efforts to improve in that area, we've even gone up to the Supreme Court of Canada on a couple of cases to get the jurisprudence right. And we're just really nailing that down now in the new act. I would say those are two areas that parties should watch for. Otherwise, though, it's just, I love our new act because it actually tracks an arbitration process. You can learn a lot about arbitration just by reading our new legislation, whereas you certainly could not have under our existing act, soon to be repealed and replaced on September 1st.
Well, and finally, are there any, do they state in the act, are there certain things because of public policy that are not arbitrable under the act?
It doesn't state it, but it incorporates, certainly the courts have a discretion. Like there are certain matters like criminal law, obviously you couldn't arbitrate. But the scope is on public policy grounds, the courts could say you can't arbitrate in that area. But, you know, within a wide range, you can indeed arbitrate, and you can arbitrate under different laws. You can arbitrate under religious law if you wanted to. You can arbitrate under any manner of dispute within a realm. Family law arbitration you can carry out in British Columbia too. But what we've done is that got built in briefly into our legislation in British Columbia. We've stripped that out and moved that to its own act. It's now in the Family Law Act.
That's interesting. So they do allow for family law arbitrations, but under its own law.
That is correct, and it's basically based on our model, which is the model law. But what they've done is they've changed some of the balances. There is room for considerably more court intervention in that process. You got the advantages of arbitration. You can have a quick speed, choice of arbitrator, et cetera, but with court overview, because of the public policy issues with children, with you name it, with spousal support, there's a myriad of issues of public policy nature where the courts must maintain a heightened role that they wouldn't and shouldn't have in commercial arbitration.
Yeah, that's interesting. Well, I know they do allow for family law arbitrations in New Zealand and in some other places, but it's been kind of a slow go as far as here in the US. But yet we do, of course, arbitrate many consumer and employment issues. I don't know if you want to speak to the arbitrability of consumer and employment cases pursuant to pre-dispute arbitration clauses in Canada.
That's a live issue right now, as it is in the US, of course, too. We have been closely tracking what's happened in the United States Supreme Court. I had the good fortune to actually argue one of those cases, Wellman, as an intervener on behalf of the Attorney General of British Columbia a couple of years ago. And basically the argument I made there was we saw the problem was a consumer class, but then there were business people who were, not very well off business people, the same type of contracts, and they were excluded from the class. And because this is under the Ontario Arbitration Act, and they've got a consumer back out. We don't. Please stay tuned, however. But what I essentially said is, remember and this is a key difference with the United States. I said, the legislatures in Canada can address this problem. You see it, we see it. Let us do the lifting, and they essentially acceded to that in the Wellman case.
Yeah,
so
definitely a live issue.
It is. We are working on this right now as well, and it's still at a policy stage. It's not part of the Arbitration Act reform, but what I stated in Wellman is on public record. So obviously we stated that we were concerned about it too. That concern remains. Legislative fixes, because we don't have a federal arbitration act, because the provinces have jurisdiction in this area, we can deal with this.
Mm-hmm, mm-hmm. Yeah, on a province level, which is very different from
the states, as I understand the way the Federal Arbitration Act and
right, because it preempts anything, especially if it involves interstate commerce, which is pretty much everything. So that doesn't exist in Canada the same way. I'm really reluctant to talk about U.S. law, but it is different. Having Quebec in the Federation has been a wonderful thing in a lot of ways. Why is that? Well,
because it is a distinct society and wants to have a lot of control of its own processes, the powers that Quebec gets, the other provinces get away. So we've seen this historic relative decentralization of the federation as it's gone on. That's been actually quite a good thing in many ways.
Mm-hmm. Yeah, that's a really interesting, I mean, that's a really good way of putting it and a really good way to think about it. Yeah, although some would argue that we have a couple of powerful states that maybe run the show. But well, listen, I really thank you for taking the time, and I'm excited about, congratulations on getting the new law over the line, and by the time this airs, people, it'll be the law. So this is great. So thank you so much, and I really appreciate your taking the time with me today, and have a really great weekend.
Thank you, Amy. It's been a delight to speak with you, and I look forward to doing so again in the future.